there have been other muggings. Personally, I've never been stalked, mugged, or anything like that.
Yeah, that's actually where the law starts to have some bite, because generally, and again, this generalizing across lots of different laws in lots of different places, but generally that would probably not be enough. You'd have to show something a little more than just, for example, a fear of crime, probably even if you live in a dangerous neighborhood.
What does this California decision mean more broadly? What are the implications both for the West and for the rest of the country?
So the Ninth Circuit's decision, which came in a case called Peruta, I think has some major implications, not just for the people living in the Ninth Circuit, which amounts to tens of millions of Americans, but also for Second Amendment doctrine, Second Amendment law, because it reaffirms the principle that we've known for years, which is that the right to keep and bear arms is subject to reasonable regulation. And then it also maybe reduces the chance of Supreme Court review, at least for this particular case. It's always hard to know, but now we really have a lot of uniformity in the federal courts of appeals upholding this kind of good cause restriction. And the Supreme Court tends not to get involved when there's that kind of uniformity.
In other states that don't have a high bar to get a concealed carry permit, this doesn't change that at all. It just says that they would have a right to raise the bar if they wanted to.
That's exactly right. This is just about the limits that the Constitution imposes on gun control. It doesn't say anything about what kinds of gun control states should or can pass short of that bar.
Do gun control groups have a right to say they've scored a victory in this Ninth Circuit Court of Appeals decision?
I think absolutely. I think these good cause restrictions have really been sort of the central battlefield for Second Amendment litigation for the past really 5 years. And the original panel decision here, which struck down the restriction, was one of the bigger victories, I think, for the gun rights community. So the fact that it's been now replaced with this opinion is a big win for the gun control community.
One other point, all of this is about concealed carry restrictions, not about open carry laws. That's already taken care of, I assume.
This is actually a really important point. It's actually what divides the opinions in Peruta. So technically the law that was under challenge here, according to the majority, was this restriction on concealed carry. But there's a separate California law which all but bans open carry. And so the dissenting opinions in the Peruta case, and there were some, argued that you really have to look at those together, that this near ban on concealed carry and a near ban on open carry together amount to a ban on public carry, and that goes too far. And the majority said, that's a question for another day. Here, we're just concerned with the concealed carry part of it. And so what they really disagreed about was how to frame the case, not so much how to understand the Second Amendment.
Professor Blocher, thank you very much for talking with us.
Thank you so much for having me.
Joseph Blocher is a professor of law at Duke University. He spoke to us via Skype.
Do you believe in magic? A small group of lawmakers do, and they're pushing Congress for a vote to formally recognize magic as an art. Without a rabbit